This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hello and welcome back. Today I have a story that is near and dear to my heart and might be near and dear to yours too. In a very unexpected ruling, a student loan borrower has had more than $221,000 of student loans discharged or forgiven during a bankruptcy proceeding in New York. Now, if you have ever looked into this issue, unfortunately, so many people do, student loans can't be discharged, or at least the thinking, even from legal professionals such as myself, was that the standard for discharging student loans is so unbelievably high that it might not even be worth doing. But in this case, Judge Cecelia G. Morris, the chief United States bankruptcy judge for the Southern District of New York, has shown us that we laypersons and professionals may have been misinterpreting the standard and has discharged this student loan borrower's debts. Let's take a look at how that happened. But first, student loans are a major problem in the United States. Many people, including myself, were told while they were very naive, young, maybe even a little bit stupid. I guess that's sort of the impolite way of saying naive. We were told by our parents and guidance counselors and teachers that you gotta go to college, everything depends on you going to college, et cetera, et cetera, et cetera. So any way you can get to college, go. And me, myself, in my personal circumstances, I'm the first person in my branch of the family to even go to college, let alone complete a bachelor's degree, complete a master's degree, and complete a Juris Doctor degree, let alone get a professional license and operate as an attorney in the United States and in the state of Pennsylvania. When I went to law school, I couldn't afford to do so without student loans. And the college or university made it seem, their financial advisor or whatever it is that they call the person who helps you prepare for student loans, didn't really ask any questions about whether I'd be able to afford it or pay it back, but rather just explained what I have to file and when I'll get my disbursement check, which would be the housing or support part that's allowed as part of student loans. So if you graduated with student loans and you weren't able to aggressively pay them down, I think the interest rate is something like 6.5%, which sounds really low, but it's much higher than most mortgages, and the amounts borrowed can be more than a mortgage. And in fact, because I went to school during the financial crisis of 2008, I was not able to immediately find a high-paying job after I got out of school, and my loans just have ballooned and ballooned and ballooned to the point that even I have considered whether I could meet this particular bankruptcy test, and my decision has been more to attempt to make a nonprofit organization and work for them for 10 years as part of my public student loan forgiveness program, which is part of my master promissory note in my agreement to take student loans. So you could be forgiven for thinking that this is a situation where people make their own bed and now they have to lay in it. At the same time, we're talking about pre-education people who sometimes are very desperate to find a way out of their situation, whatever that may be, and they're willing to try anything because even a bad student loan situation would be better than the situation that they were in. For me, I was struggling to get promoted at a job that I was working at where they continued to string me along, telling me that I would get a promotion, reassuring me that I would get a promotion. My performance reviews continued to be high. I kept being given more and more responsibility. I was even moved to a new building, worked with the engineers, basically became an engineering field technician, and even then wasn't somehow worthy of even a cost of living adjustment. And so I was pretty desperate, and I was willing to take the chance with student loans. And while I don't regret going to school to be a lawyer and don't regret being the lawyer that I am today, I would advise people to figure out a better way to handle their loans lest they become a poster child like me. So let's take a look at the remarkable opinion in Kevin Jared Rosenberg's case. Mr. Rosenberg is a pro se bankruptcy litigant, meaning he's representing himself, which is really interesting because even a pro se litigant can do this. Now, big disclaimer, the Brunner test that we're going to talk about here only applies in several of the circuit courts of appeal or the district courts around the country, the regions of district courts around the country. And you'll need help if you're going to try and do this for yourself. If you don't know what you're doing, there's a very good chance you might do it wrong. So this is not legal advice. The advice is go talk to a competent bankruptcy attorney, maybe even talk to several, because it's probably going to be an investment for you, both time and money, in making sure that you have all of your I's dotted, T's crossed. Everything in the bankruptcy petition needs to be pretty much perfect. Even the Department of Justice likes to keep an eye on bankruptcy petitions to make sure that no one is gaming the system. So it's a tremendous risk to file bankruptcy as well. It follows you for at least 8 years. Lenders will look at a bankruptcy petition in your past and knock you down in credit score and lending ability. However, the opposite is also pretty horrible. High student loans means I can never get a loan for anything, not even to refinance the mortgage on my house, as lenders will look at it as a risk that I don't make enough money to support the student loans I've already got. So how could I possibly be given more money in a loan? Even if I do have the income and ability to pay it back, they still don't want to lend to people. So you get dinged on your credit score as well there, and you get dinged on your ability to get a loan for basically anything at all. You'll pay higher interest rates. This is what we call the poverty tax or the poor tax. Just being poor or just having bad cash flow or having a bankruptcy in your past or having high student loans, all of these things count against you, making things cost more, making you have fewer options and perpetuating the situation of being in poverty or being in debt. This is a remarkable opinion, and I hope you enjoy the possibilities that are opened by Judge Morris's opinion. Okay, so first we should note that this opinion is marked for publication, which means this is considered a precedential opinion, which should be published in the summary of precedential opinions. This is from the Southern District of New York Bankruptcy Court. And in case you're looking for this opinion and for the actual bankruptcy filing, the petitioner is Kevin Jared Rosenberg, and the defendant is the New York State Higher Education Services. Now, normally you wouldn't have a plaintiff and defendant in a bankruptcy petition, but rather this was an adversarial action filed during the bankruptcy, which is what you have to do when you need to overcome something like the law that says that you can't discharge student loans. When I say discharge, that's the legal term that applies when we're referring to forgiving or getting rid of a debt in bankruptcy. So after a successful bankruptcy petition and creditors meeting and all that, you end up getting a complete discharge of applicable loans, and those debts are wiped out. So once again, this is before Judge Cecelia G. Morris, the Chief United States Bankruptcy Judge, and she writes, "The petitioner, Mr. Rosenberg, brings this summary judgment action asking the court to declare the debt owed to Educational Credit Management Corporation dischargeable pursuant to Bankruptcy Section 523A8. We'll go over that in a moment. For the reasons set forth in this decision, plaintiff's motion for summary judgment is granted. Defendant's cross motion for summary judgment is denied. Background. Petitioner filed a petition for relief under Chapter 7, which is liquidation, of the Bankruptcy Code on March 12, 2018. The petitioner received a discharge of his debts on July 26, 2019. On June 18, 2018, the petitioner filed this adversary proceeding to have his student loan debt declared dischargeable pursuant to 11 U.S.C. 523A8. And there's a footnote here. Because we're on a pro se standard, the court liberally construes the documents as required by the Supreme Court in Erickson via Pardus, a 2007 Supreme Court case. On November 14, 2018, the parties entered into a consent order allowing ECMC to intervene in this adversary proceeding, as they are the company that ended up holding one of his federal consolidation loans. Petitioner filed a motion for summary judgment on August 27, 2019. The student loan company filed a cross motion for summary judgment to oppose petitioner's motion October 8, 2019. So this just happened. The parties agree that there are no genuine issues of material fact, and this issue is ripe for summary judgment. That's the summary judgment standard. If there's anything that has to go to trial, we have to go to trial. The court held a hearing on October 29th, asking the parties to provide the court with evidence as to the current promissory note, the current terms of the loan, the current principal balance, and the payment history. The student loan servicer filed a response which contains payment history since consolidation of the loan. Petitioner began borrowing money to fund his education in August of 1993. From 93 to 96, petitioner continued to borrow money to pay for his undergraduate education at the University of Arizona. After obtaining a Bachelor of Arts degree in history, he served in the U.S. Navy on active duty for 5 years. After completing his tour of duty, petitioner attended Cardozo Law School at Yeshiva University, where he applied for and received additional student loans to cover his tuition and board from 2001 to 2004. After graduating from law school, petitioner consolidated his student loan on April 22, 2005 in the original principal amount of $116,464.75. The total outstanding balance of this student loan as of November 19, 2019 was $221,385.49, with an interest rate of 3.38% per year. The dischargeability of this student loan is the subject of these summary judgment motions. Pursuant to Rule 56, this is an adversary proceeding, and summary judgment should be granted to the moving party if the court determines that the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to judgment as a matter of law. That is the Celotex case, which you'll see oft cited for summary judgment standards. The materiality of facts must be determined with reference to the governing substantive law. A fact is material only if it affects the result of the proceeding, and a fact is in dispute only when the opposing party submits evidence such that a trial would be required to resolve the differences. A movant has the initial burden of establishing the absence of any genuine issue of material fact. A moving party may obtain summary judgment by showing that little or no evidence may be found in support of the non-moving party's case. The non-moving party must do more than simply show there is some metaphysical doubt as to material facts. The non-moving party should oppose the motion for summary judgment with evidence that is admissible at trial. So to try and give you a reference point, the moving party is, in this case, the bankruptcy petitioner, and the non-moving party is the student loan servicer. Now, the student loan servicer filed their own motion for summary judgment, so those terms are then reversed, but that's the awkward language that is used. If you can come up with better language, good for you, but this is the best that I think the legal system can do. Under 11 U.S.C. 523A8, a discharge, remember that's forgiveness or getting rid of the loans. A discharge under Section 727 of the Bankruptcy Code does not discharge an individual debtor from any debt unless accepting such debt from discharge under this paragraph would impose an undue hardship on the debtor and the debtor's dependents. So that's the standard we're on here. And it does not discharge debts for an educational benefit overpayment or loan, guaranteed by a government unit, or made under any program funded in whole or in part by a government unit or nonprofit institution, or an obligation to repay funds received as an educational benefit, or any other educational loan that is qualified as an education loan. Both the petitioner and the student loan servicer agree that the proper test to be applied in this instance is the Brunner test from Brunner v. New York State Higher Education Services Corporation, known as In re Brunner. It is a Second Circuit 1987 case that was denied certiorari to the United States Supreme Court. So the Supreme Court could have taken the case and overturned the Brunner test, but they didn't. So the Brunner test remains law in the Second Circuit, and a number of other circuits have adopted the Brunner test as well. The Brunner test is that if the debtor cannot maintain, based on current income and expenses, a minimal standard of living for herself and dependents if forced to repay the loans, and that additional circumstances exist that this state of affairs is likely to persist for a significant portion of the repayment period, and the debtor has made a good faith effort to repay the loans, then the loans can be discharged. The court writes, however, in the remarkable part of the opinion, Brunner has received a lot of criticism for creating too high of a burden for most bankruptcy petitioners to meet. For petitioners like Brunner, who filed for bankruptcy approximately 7 months after receiving a degree, the Brunner test is difficult to meet. However, with a multitude of petitioners like Mr. Rosenberg, who have been out of school and struggling with student loan debt for many years, the test itself is fairly straightforward and simple. The harsh results that often are associated with Brunner are actually the result of cases interpreting Brunner. Over the past 32 years, many cases have pinned on Brunner punitive standards that are not contained therein. See Briscoe versus Bank of New York, coining the infamous and oft-repeated term certainty of hopelessness, but not applying the Brunner test, which was not established until 6 years later. See Jean-Baptiste versus Education Credit Management Corporation, requiring proof of a certainty of hopelessness despite the plain and straightforward language of Brunner. That was in 2018. Those retributive dicta, or non-binding court analyses, were then applied and reapplied so frequently in the context of Brunner that they have subsumed the actual language of the Brunner test. They have become a quasi-standard of mythic proportions, so much so that most people, including bankruptcy professionals and lay individuals, believe it is impossible to discharge student loans. To this end, some courts have even called it bad faith when someone struggling with repaying a student loan attempts to discharge that debt in bankruptcy court. The court is not insinuating that filing a bankruptcy petition in order to rid oneself of a crushing $300,000 plus of student loan debt could ever be considered bad faith. Bankruptcy is an available and beneficial option for anyone struggling with debt, and a petitioner under the Bankruptcy Code always has the option to come before the court and ask in good faith that a debt be discharged, no matter what kind of debt that is. And the court notes in footnote 3, of course, a harsh standard made sense when student loans were fully dischargeable after making only 5 years of payments, and when the total due on the loan was approximately $9,000 for both undergraduate and graduate student loans. I think circumstances have changed since then. See In re LK, a 2009 EDNY petition denying discharge to a debtor whose student loan debt constituted 70% of the debt scheduled in a bankruptcy case. See Holzer versus Wachovia Services, a good faith prong not satisfied where student loans were the only debts listed in debtor schedules. And see De Torre versus DeVry, dismissing debtor's complaint where student loans constituted 82% of debtor's total debts. This court will not participate in perpetuating these myths. It is important not to allow judicial glosses to supersede the statute itself. Rather, this court will apply the Brunner test as it was originally intended. On the first prong, whether the petitioner cannot maintain, based on current income and expenses, a minimal standard of living for himself and his dependents if forced to repay the loans. Under the first prong of the test, the court must determine that the debtor cannot maintain, based on current income and expenses, a minimal standard of living for himself and his dependents if forced to repay the loans. It should be noted that the test asks the court to base its determination as to whether petitioner can maintain a minimal standard of living using only petitioner's current income and expenses. Section 707b2 codifies the means test, which is a formula that calculates a bankruptcy petitioner's average monthly disposable income over a 60-month period by deducting statutorily specified allowable expenses, secured debt payments, and priority debt payments from current monthly income. Current monthly income is defined in 11 U.S.C. 101-10A as the average monthly income of a debtor from all sources in the 6-month period prior to commencement of the bankruptcy case. Here, the petitioner's means test lists his monthly income as $3,136.24 and his annual income as $37,634.88. Petitioner lists his income and expenses on Schedules I and J as $2,456 in income and $4,005 in expenses, leaving the petitioner with a current monthly income of negative $1,548 at the time of filing. Thus, petitioner has declared under penalty of perjury that he has negative income each month. The Bankruptcy Code presumes that a petitioner who seeks its protection will deal honestly and fairly with creditors by furnishing a complete and accurate schedule of assets. The bankruptcy schedules and statement of financial affairs of a debtor serve the vital role for creditors in a bankruptcy case in that they ensure that adequate and truthful information is available to trustees and creditors, not just an objecting creditor, without the need for further investigation to determine whether or not the information is true and correct. Neither the student loan servicer nor any other party in interest has objected to petitioner's schedules or means test, and petitioner has received a discharge. Therefore, the court accepts the petitioner's income and expenses as undisputed. As of the filing of this bankruptcy case, petitioner's student loan is currently in default. As such, his student loan is currently due and payable in the full amount of $221,385.49, plus interests and costs. Petitioner has successfully proven that he cannot immediately pay his student loan in full on his current income. Petitioner is not currently in a repayment plan, nor is he eligible for one. To become eligible for a monthly repayment plan, petitioner would have to rehabilitate his loan by agreeing in writing to make 9 voluntary, reasonable, and affordable monthly payments within 20 days of the due date and make all 9 payments during a period of 10 consecutive months. Petitioner's rehabilitation payment would depend on his current monthly income. Such an agreement is not currently before the court. An unaccepted settlement offer or offer of judgment does not moot a plaintiff's case. And the question of whether the petitioner could maintain a minimal standard of living while rehabilitating his student loan is appropriately reserved for a case in which it is not hypothetical. As the petitioner has a negative income each month, he has no money available to repay his student loan and maintain a minimal standard of living. The first prong of this test is met. The second prong is whether additional circumstances exist indicating that this state of affairs is likely to persist for a significant portion of the repayment period of the student loans. Next, the court must consider whether additional circumstances exist. It should be noted that the Brunner test does not require the court to make a determination that the petitioner's state of affairs are going to persist forever, as the student loan servicer argues was required in another case. Nor does the test require that the court make a determination about whether the petitioner's state of affairs was created by choice, as the ECMC student loan servicer suggests. The court need only consider whether the petitioner's present state of affairs is likely to persist for a significant portion of the repayment period of the current contractual student loans. The final report and recommendations from the ABI Commission on Consumer Bankruptcy recommends that the court consider the debt and not some different contract the debtor and creditor might have made under different circumstances. Here, the repayment period has ended, petitioner is in default, and his loan was accelerated. As of November 19, 2019, petitioner is responsible for the repayment of the full amount of $221,385.49. His circumstances will certainly exist for the remainder of the repayment period, as the repayment period has ended, and the loan is due and payable in the full amount. The second prong of the Brunner test is therefore satisfied. So that's interesting. That means that when your student loan is in default and they accelerate your payment so that you owe the full amount immediately, that possibly satisfies the Brunner test, because if you're not in a position to pay the full amount off, really ever, then there's nothing else to really discuss there. The third prong, whether the debtor has made good faith efforts to repay the loans. The court must determine whether the debtor has made good faith efforts. The Brunner test asks the court to look at whether the petitioner has made good faith efforts to repay the loan, which indicates that the court should only consider petitioner's past behavior in repaying the loans. It is, therefore, inappropriate to consider petitioner's reasons for filing bankruptcy, how much debt he has, or whether the petitioner rejected repayment options. See Kelly versus Sally Mae Servicing, concluding that the debtor failed to show good faith because she rejected consolidation options. Based on the loan history provided by the servicer, petitioner missed only 16 payments in the almost 13 years since this student loan originated in April 2005. From April 2005 to 2015, the loan was in deferment or forbearance. No payments were due, no late fees were charged. Thus, until April 2015, petitioner was fully current on this debt and no payments were due. On April 6, 2015, the loan went into income-based repayment for 1 year. Debtor testified at his deposition that he was to make payments of $300 a month for the first year, and it was going to increase by $100 a month every year thereafter, with a maximum of $1,000 a month until it was repaid. This has not been refuted by the student loan servicer and matches the student loan payment history provided by them. During the first year of the repayment plan period, petitioner made 6 payments of varying amounts. For example, May of 2015 was a payment of $229.31, $500 August 14th, $300 October 14th, $346 November 2015, $458 January 2016, $249 January 2016. His income-based repayment plan ended in April 2016, and the account was in forbearance again from April 2016 to October 2016. Despite the fact that no payments were due, petitioner continued making payments. There was a $700 payment in 2016, a $50 payment in 2018, and a $50 payment in September of 2016. The petitioner's student loan entered into standard repayment October 6, 2016, and the petitioner made one additional payment of $100 in February of 2017. On January 8, 2018, the account entered default and was paid in full by the guarantor, which would probably be the government, I think. Petitioner made 10 payments in varying amounts during the 26 months that petitioner was responsible for making payments, which is approximately a 40% rate of payment over a 13-year period. Additionally, the petitioner did not sit back for 20 years, but made a good faith effort to repay his loan. He actively called and requested forbearance on at least 5 separate occasions, all of which were granted by the servicer. The petitioner has demonstrated a good faith effort to repay the loan and has satisfied the undue hardship standard of the Bankruptcy Code. For the foregoing reasons, petitioner has satisfied the Brunner test. Based on the foregoing, it is ordered that the student loan imposes an undue hardship and is discharged. And that is the Honorable Cecelia G. Morris, Chief United States Bankruptcy Judge in the Southern District of New York in Poughkeepsie, New York. She just filed this on January 7th, 2020. Now, that is not the end of it, because immediately the ECMC student loan servicer has appealed. The Educational Credit Management Corporation hereby applies for leave to appeal. They explain about summary judgment motions, and then here's the facts. The facts underlying ECMC's summary judgment motion are not in dispute. Plaintiff is a 46-year-old healthy individual with no dependents. He is college educated with a Bachelor of Arts and JD degree, that's the law degree, the latter of which was financed through federal student loans held by ECMC. Plaintiff is licensed to practice law in New York and New Jersey. He voluntarily left his first job as an associate attorney at a law firm after only 2.5 months because he did not find the work interesting. Plaintiff, with the exception of a brief period of working as a part-time contract attorney, has not sought any other employment in the legal profession and has no intention of ever doing so. The record contains an uncontroverted vocational expert evaluation which demonstrates that earning opportunities abound for Plaintiff in the legal profession. Instead of pursuing those opportunities available to him and paying back his taxpayer-funded student loans, Plaintiff for the past 10 years has held various positions in the outdoor adventure industry, including starting up and running his own tour guide business. Section 523A8 of the Bankruptcy Code provides that student loan debt is not dischargeable. They repeat the Brunner test, and then they say, over the next 20 years, 7 other federal circuits followed suit, adopting the Brunner test. Along the way, a breadth of case law has emerged. Because Congress selected the word undue, the required hardship under Section 523 must be more than the usual hardship that accompanies bankruptcy. Inability to pay one's debts by itself cannot be sufficient to establish an undue hardship. Otherwise, all bankruptcy litigants would have an undue hardship. The bankruptcy court in this case at hand rejected 32 years of case law applying the Brunner test in order to determine on summary judgment that Plaintiff met his burden to establish an undue hardship, and therefore discharging him of the entire student loan debt of approximately $221,385. So holy mackerel, that is remarkable. If the appeals court decides that this was a correct application of the Brunner test, I expect a flood of new bankruptcy petitions to be filed alleging that other student loan borrowers meet the Brunner test and should have their student loans discharged as well. In fact, I'm still on my path of trying to go through public service student loan forgiveness. You see what we're doing here with Lawful Masses. I think it'll be a no-brainer to convert it over to a nonprofit organization and work for that for 10 years. In fact, I might even be able to improve my own personal income situation while also being able to serve the public in a access to justice kind of way, like you see here, because I'll be able to overcome the uncertainty that comes with running your own for-profit business in the form of a law practice in this case. So what do you think of that? Let us know in the comments below. Share this video with everybody you know, because we really have to spread the word that this is an option that is available for people. Of course, anyone who's actually considering legal action, especially the difficulty of bankruptcy, should be talking to a bankruptcy attorney. If a petitioner really has to do this pro se, please don't take this video as legal advice. Maybe, if anything, take some of those citations and go do your own research. Look at what this petitioner did exactly. It takes a lot of work to file a bankruptcy, and it must be done properly, or else the whole thing is for naught and you can't file again for a number of years. It's a terrible situation, the student loan crisis in the United States. Student loan debt in the US currently tops over $900 billion of total borrowing, while the US military budget is around $693 billion. So if in exchange for some of the military budget, we could take care of a tremendous amount of student loan debt. There is no way that I see the people of the United States paying back $1 trillion in student loan debt. But hey, I'm no economist, so don't hold me to that. If you have ideas of how to deal with this, go for it. My idea is just to work on my own personal circumstances and go from there. Speaking of those personal circumstances, this is a community-supported legal education channel. Thank you for watching. Thank you for your financial support on patreon.com/ljfrench and sponsors.com/law. Your money goes directly to helping us produce more videos, keeping me alive so I can continue to serve you as your favorite legal education and news YouTube channel. Thank you very much to our January $50 plus supporters: Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Jan Negrey, Spirit Bear, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Steven, Cute Grills in your area, and Ottah. Looking forward to the new supporters coming up here on February 1st. You'll get charged on February 1st, and we will start the crawls for you on February 2nd. Thank you very much to our $5 plus supporters who are scrolling on the screen in front of me. I'm Leonard French, your favorite copyright attorney. I love you all. I'll see you in the next one. Bye.